Good afternoon, everyone. It's Thursday, February 6th, 2025. We're running a bit late, so it's about 3:08 p.m. And I'm calling the meeting of the Senate Elections Committee to order. We're in room 1200, and it's a nice day outside. So we have some interesting things to run past today. 3 items on the agenda. And the first is going to be a reappointment confirmation for the Campaign Finance and Public Disclosure Board. It's going to be for Mr. Stephen Swanson, and he's going to join us via virtual connection. And what we have is Mr. Jeff Sigurdson from the Campaign Finance and Public Disclosure Board up at the testifier table in case there are any questions. So what we'll do right now is perhaps we can switch to Mr. Swanson, and he can give us a bit of a bio and some background on himself.
Thank you, Mr. Chairman, and good afternoon to you and members of the committee. First of all, let me express my appreciation for your invitation to appear before you today and to do it virtually. I'm having a little trouble getting around these days, and especially in the winter. So I appreciate the courtesy that you've shown me. I've been on the board now going on 8 years. A quick bio. My wife, Bea, and I came here in 1971, having met in Vista in New York City. I had a job with Minneapolis Legal Aid Society, worked there for around 20 years, and 10 of those years was as the managing attorney of the Legal Services Advocacy Project, which continues to exist today. So I was a full-time lobbyist for about 10 years in the late 70s to mid-80s at the legislature before administrative agencies. So I learned a lot about the legislative process. I learned how important it was for people in the public to understand what was happening at the Capitol, who was doing it, what lobbyists do. After that career, I was appointed to the Hennepin County District Court and was a district court judge for about 20 years. During that time, I had an opportunity through a leave of absence program that the Supreme Court approved to work in Bosnia and Herzegovina, where I later became an international judge on that court. I got some experience there. On the district court bench in 2007 to take a position with a USAID rule of law project in Afghanistan and lived in Kabul for 2 years. Came back from that position and was a full-time judge as a senior judge for a couple years more on the Hennepin County District Court. Then I had an opportunity to do USAID work in Lebanon and Poland. Since then, I've been a part-time federal law judge for the Office of Administrative Hearings. I've been a half-time housing attorney with the Volunteer Lawyers Network, and I've done some volunteering in other ways. I've just recently taken a position assisting the trustee for the very large bankruptcy court trust that's handling claims by Boy Scouts of being sexually offended during their Boy Scout experience. So I'm interviewing Boy Scouts at the moment as part of that team. That gives you a brief understanding of what I've done. I know you have the information I supplied when I filed for reappointment. I'd be happy to answer any questions that you, Mr. Chair, members of this committee may have. But I will say that preparing for this appearance today, made me consider, why do I want to be reappointed? What is it about the Campaign Finance Board that draws me to want to continue to serve on them? And the best way I can describe it is it gives me an opportunity to continue providing service to the public. And I've grown a great deal of respect for not only the board, but more importantly, for Jeff Sigurdson and his team's work for the agency. They do a wonderful job of working with the public and with the regulated community. I also very much enjoyed the collegial atmosphere on the board. As you know, it's a 6-person board with a balance of political backgrounds and interests. So I've learned a lot from my colleagues, and I look forward to continuing on the board. The work, I think, is challenging, it's important, and it's very fulfilling for me. So thank you, Mr. Chairman, for the opportunity to appear before you today.
Well, thank you, Mr. Swanson. And I know you've served with distinction on the board since your appointment in 2017. And from what I see is in notes here is that your legal experience has really been indispensable to the board. And I see also in your application information that you're interested in making sure that we do make, we pay attention to the funding of elections, and that that helps us have a free and open and honest electoral process. And I think everybody on this committee shares that feeling that we need to make sure that we're promoting free and fair elections. And with that, I'd open the mics to any questions from the committee members. We have some members that have to be online today. Any questions from the members that are online? With that, I might have one question myself. Mr. Swanson, what do you think that we maybe should pay more attention to in our examination of funding of elections? Is there something that is at the top of your mind?
Thank you, Mr. Chairman, and thank you for the kind words. I think at the top of my mind is the need to ensure that corporations are not participating by either in-kind contributions or other types of contributions in the electoral process in Minnesota. I know the statute prohibits it, and I think that probably is one of the challenges that will continue to confront you and the members of your committee and the legislature and the board as we go forward into the next election season.
Yeah, thank you, Mr. Swanson. I'll open the mics again. Anybody have any further questions? If not, we can move to a motion. I'm going to ask Senator Swazinski.
Just say what he. Just say
Senator Swazinski moves that Stephen Swanson's appointment to the Campaign Finance Public Disclosure Board be recommended for confirmation. And with that, we'll have a vote. All in favor, say aye.
Aye.
All opposed, say nay. The motion is adopted, and Stephen Swanson's appointment to the Campaign Finance Board is recommended for confirmation.
Thank you very much, Mr. Chairman and members of the committee.
Thank you. Next, we have a bill from Senator Dibble. Senator Dibble has some testifiers, so we'll try to be succinct and brief. And I'll ask Senator Dibble to decide which ones will testify first. So Senator Dibble.
Thank you, Mr. Chair and members, for the opportunity to present Senate File number 48. This is a proposal that's been before this committee in years past, or at least 1 year past, and it has to do with amending our state's constitution so that elections would be free, fair, and equal, with no civil or military power being allowed to at any time interfere with the free exercise of the right to vote. It's fairly straightforward, and of course the goal is to uphold, I think, our shared value that voting in elections are the embodiment of our democratic system of representative government. We understand very clearly that for every person, they are entitled to one vote. Every citizen is equal, regardless of the circumstances of their birth, fully equal in the eyes of the law. That being said, we have seen in recent years many policies at the state level that have been pursued, some enacted, that have the opposite effect of that stated value and inhibit people's access, citizens' access to voting. Other policies have been enacted that allow for distorting of our electoral system, whether through gerrymandering or the nature of the funding systems that are in place in terms of amounts of funds and lack of disclosure and sources. Many have looked to our federal courts and federal legislation to remedy those policies. However, we've seen some corrosion even at that level in a number of rulings of the Supreme Court. But on the subject of the Supreme Court, I think the last time that I presented this bill, a particular case was pending decision that had to do with the independent state legislature theory. And we were fairly nervous about how the Supreme Court might rule on that. The theory was that, and what was being proposed by the plaintiffs was that only legislatures have the right to determine voting systems and electoral systems, and specifically electoral maps, with no right of judicial review, regardless of what's found in their state's constitution. No subject of any matter in their state Supreme Court could have any effect on their decisions as a legislature. The Supreme Court rejected that theory and actually found that legislatures' decisions in this arena are subjected to judicial review and can rely on what their constitutions say. Our U.S. Constitution is silent on voting rights. And of course, we know that, as I said before, broad aspects of the U.S. Voting Rights Act have been voided. Our state constitution is not silent entirely on the matter of elections and voting. It does have a number of particularities with respect to who is entitled to vote, other administrative matters, but this statement of fundamental rights and principles is lacking in our state's constitution. 30 other states do have such language specifying that voting and elections be free, fair, equal, open, articulate that no power, civil or military, can infringe on that right. And that language has been successfully relied upon in lawsuits that eliminate policies that are passed by legislatures that are designed to suppress voters' rights, unfair gerrymandering, unfair campaign practices that do not uphold the public's interests, but uphold a narrow set of interests, those who are more powerful and have more money in the equation. Examples include Pennsylvania, which struck down a gerrymandered map and an onerous voter ID requirement. North Dakota struck down rules designed to create a specific difficulties for Native American citizens to vote. Montana struck down a law that limited voters to owners of real property. We thought that was an obsolete idea, of course, going back to kind of pre-Civil War era, but as such, there was an attempt to promote an idea. Also, there was an effort to restrict those who needed voting assistance, and it was, those limitations were struck down as well. So with that, Mr. Chair, that's the presentation of my proposal and my idea to amend our state's constitution so that it's reflective of what we find in 30 other states' constitutions to make voting more fair, more open, more accessible, so that that basic right as a citizen is secured. So we do have Dave Fisher here from Clean Elections Minnesota, who can kick us off with their testimony, and then we'll have Gene Massey.
Identify yourself, please identify yourself for the record and then proceed with your testimony.
Yes, sir. Thank you. So I'll start out, Chair Carlson and committee members and Senator Dibble. My name is David Fisher. I'm with Clean Elections Minnesota, supporting Senate File 529, securing the right to vote in our state. I teach at the University of Minnesota Law School, serve as an election official, and previously served as a Minnesota State Commissioner. Next month is the 59th anniversary of Bloody Sunday in Selma, Alabama, where government tried to beat into silence Black Americans marching for their right to vote. In response, Congress passed the Voting Rights Act, when then President Johnson said, "The right to vote is the most powerful instrument ever devised for breaking down injustice." And Johnson is not alone. In 1974, no less than a scholar than Justice William Rehnquist wrote in the case Richardson versus Ramirez, quote, "Because the right to vote is of the essence of a democratic society, and any restrictions on that right strike at the heart of representative government, voting is a fundamental right." And more recently, again in Selma, Joe Biden said, "The right to vote and to have your vote counted is a threshold of democracy and liberty. With it, anything is possible. Without that right, nothing is possible." So I'm puzzled that constitutions guiding us are said not to confer a right to vote on anyone. Meanwhile, we've seen in recent years an absolute explosion of state laws and election litigation and escalating uncertainty and distrust of election rules, often designed to suppress the franchise by putting barriers before eligible voters. And this is so even though political scientists like Darren Shaw and John Petrosic, in their book, The Turnout Myth, debunk the claim that voter suppression and low voter turnout help one political party gain over another. Senate File 529 can clear the air in Minnesota. It will enshrine for this and future generations that all eligible voters can cast a vote that will be counted, while minimizing litigation challenges and disruption and deterring election fraud. Clearly drafted, politicians and judges would be unable to ignore the command of this amendment. 30 other states have enshrined this principle in their constitutions, and as Senator Dibble has pointed out, in states like Pennsylvania, Montana, and North Dakota, these provisions have thwarted voter suppression laws and protected electoral integrity. And this is not a partisan issue, it's an American issue. The right to vote is essential to a government of the people, by the people, and for the people. And Clean Elections Minnesota urges this committee to take action supporting Senate File 529. Thank you, and I can take questions at the appropriate time.
So, Mr. Chair, I think I referred to Senate File.
Swanson.
Excuse me, Mr. Chair. I referred to Senate File 48. That was last year's bill number. I cribbed some of my notes from last year's file. So
I did hear that, and I was wondering if you were going to catch it. Thank you. Thank you, Senator Dibble. And your next testifier, please identify yourself for the record and continue with your testimony.
Good afternoon, Chair Carlson and members of the committee. I'm Jean Massey, and I'm the Executive Director at Fair Vote Minnesota, a nonpartisan organization dedicated to ensuring our electoral systems are fair, free, competitive, inclusive, and fully representative of all voters. I'm also an election judge. I come before you today to strongly support the proposed constitutional amendment to enshrine the right to free, fair, and equal elections in the Minnesota Constitution. At a time when the integrity of our electoral process is under increasing scrutiny and threats to our democracy are growing nationwide, Minnesota should take decisive action to protect the fundamental right of every citizen to vote and to have their vote counted in an election that is fair, accessible, and secure. Minnesota has been a long-time leader in voter participation, but we cannot take that status for granted. We've already seen efforts across the country to roll back voting rights, and while Minnesota so far has resisted such anti-democratic measures, we must not assume that we are immune from these threats in the future. By explicitly guaranteeing the right to free, fair, and equal elections in our state constitution, we create a vital safeguard against any future attempts to weaken the foundations of our democracy. This amendment would ensure elections in Minnesota remain accessible, transparent, and accountable, protecting voters from disenfranchisement, political interference, and discriminatory election practices. Additionally, it would prohibit any civil or military interference in our electoral process. As David had pointed out, it's not a partisan issue. It's a fundamental democratic principle. All Minnesotans, regardless of political affiliation, should have confidence that their elections are conducted freely and fairly, and that their voices are heard, and that their votes matter. This amendment affirms the core American principles of democracy and self-governance, and ensures future generations of Minnesotans will continue to enjoy free and fair elections. I urge you to support this measure and allow Minnesota voters to decide whether to enshrine these critical protections in our state constitution. The right to vote is the cornerstone of our democracy, and we must do everything in our power to safeguard it for all. Thank you for your time and consideration. I appreciate the opportunity to speak on this important issue.
Thank you, Ms. Massey. Do we have any other testifiers for the bill? Okay. And any questions from the committee? Senator Bolden.
Thank you, Mr. Chair. Not a question, but just a comment. Thank you, Senator Dibble, for bringing this bill. I'm proud to be a co-author on it. Minnesotans are voters, and making sure that we enshrine the right to free, fair, and equal elections is really fundamental, especially, as was mentioned, in a time when we are seeing the rise of anti-democratic and vote, movements and voter suppression, and as we are seeing the landscape across the country. And so this is important. I'm proud to support it. And when we get to the point of a vote, Mr. Chair, I would ask for a roll call.
Roll call requested, roll call granted. Other questions? I think I had Senator Coran next.
Thank you, Mr. Chair. Senator Dibble, I know we heard this bill before, and we always tout Minnesota as having the most wonderful, free, fair, open elections, most trustworthy. And we've seen a whole host, maybe I'll become a bigger fan of it, because we've seen a whole host of legislation to remove the transparency, to build trustworthiness and accountability in elections. But we have the highest turnout rates in the nation. Every year we celebrate those things. How will this improve that?
Senator Dibble.
Thank you, Mr. Chair. Thank you, Senator Cran. I agree with you, and in fact, I think I get into arguments with some of my colleagues about who has the highest voter turnout by both number and percentage. I think my district has the highest, but sometimes I argue with Senator Murphy, Senator Johnson Stewart about that. But even so, of course, we brag about our 80% voter turnout, which is amazing. But when you think about that, that means 1 in 5 eligible voters are not. That's a lot. There's always room for improvement. What this would hope to address, Mr. Chair and members, is also to provide, it sends a strong signal of, this is a fundamental value. It's a huge glaring gap in our Constitution. It's kind of a surprise that we don't have this, given the fact that most other states do. We do have, an entire Article 7 on the elective franchise, and then in Article 1 in our Bill of Rights, it touches in a couple of places around basic rights and privileges and, religious tests and the like. But, to establish this as a basic fundamental right that's enumerated in the Constitution, which of course is the voice of the people, I think is a very, very strong statement and a very strong value and a huge gap in our state's constitution. But it also will serve as something of a guidepost for us as legislators, because as we seek to pass laws that affect the contours and the circumstances of our electoral and voting system, as well as our executive branch, chief executive, as they're contemplating what kinds of legislation to support or not, to really serve as our North Star, if you will, when we're thinking about different ideas, to make sure that they conform to that basic principle of freedom, of fairness, and equality.
Mr. Chair, follow.
Yes, Senator Grant.
Thank you, Senator Dibble. You gave examples earlier of things that happen around the country and how this has been utilized. But free, fair, and equal really doesn't have any definition. It's extraordinarily broad. And so the interpretation could be seen on the opposite side of enabling the courts to determine election law against the will of a legislative action. Without any definitions, then how would they make those decisions? I could argue on the other side, on what I believe the challenges of continued removal of transparency in our current election laws, which maybe doesn't allow it to be free, fair, and equal. But it seems like it could be an attorney, a lawyer, funding mechanism, or just to fill the courts again. We've always battled the gerrymandering and all of the things that we battled, both sides on those things. But with no definitions, it's a very broad set of criteria, 3 words with no definition. And so literally every single action could be measured up against it. And we talk about all of these things that have happened all over the country about limit access to ballots or limit access to voting. I don't know how that happens in a state that has an election season that's 46 days and no verification of who even votes hardly in many cases. And so where's the definition? What's the guidelines to remove the judiciary from making that law outside of the legislature when free, fair, and equal don't even have any definitions?
Thank you.
Senator Dibble.
So I would respond, thank you for the question. It's a great question, and I would respond by saying I'm not a constitutional lawyer, so maybe my lawyer friend can help. I'll phone a friend, but I'll take a shot at it, and he'll correct me if I'm wrong here. But we do find, within the balance of the state's constitution, this idea that, within the Bill of Rights, no member shall be disenfranchised or deprived of any rights or privileges that they're secured to any citizen, et cetera. We have some places in the elective franchise where the idea of the right to vote is touched upon. Every person, it's in the context of where they exactly would vote and under what circumstances, but it says every person 18 years of age or more who has been a citizen of the United States, et cetera, shall be entitled to vote. Again, it's qualified around where they vote, and et cetera. But, I think it sends a pretty strong indication of what we're talking about when we say that elections shall be free, fair, and equal. I would say that I would invite the judiciary from time to time to scrutinize what the legislature does. I think more often we see efforts that are proposed. There are a number of proposals in the legislature that you may disagree. I'm sure some of you do disagree with my characterization, but I think they would end up having the effect of inhibiting more people and keeping more people from voting than otherwise would be able to vote. And I would invite the courts to exercise their right to judicial review of the ideas that we have around voting and elections. Because I think that opportunity for judicial review is an important balance to the ideas that we have, as was upheld by the Supreme Court decision, which was questioning the theory that was brought by the North Carolina legislature, who said we can just draw the lines as we see fit, and the North Carolina Supreme Court doesn't really have any right to review that decision. And the Supreme Court said, no, in fact, the Supreme Court would have the right to do so, and as indicated in the North Carolina Constitution.
Thank you, Senator Dibble. No further questions at this time.
Thank you. Senator Lucero.
Thank you, Mr. Chair, and thank you, Senator Dibble. Just a couple questions. So is it your intent that the word civil on line 1.14, that would prohibit, when it speaks of prohibiting civil and military powers, that the word civil there would prohibit a future civil authority from enforcing voter ID?
Senator Dibble.
Senator Lucero, I think the use of the word civil is to distinguish from military power. And so, you know, in terms of voter ID, you know, I won't be drawn into the specific conversation about whether or not voter ID is a good idea. But the idea of civil, of course, is in contrast to military power. If in fact the legislature, for example, which is not a military power, it's a civil power, or a city council, or just an individual who's out there, you know, blocking the entryway to or, you know, messing around with folks who are on their way to go vote, you know, that's in the civil realm, not the military realm. If they're doing things that have been found by the courts, or, you know, in our judgment as we read the Constitution, as we're contemplating legislative changes, to be contrary to the requirement that they be free, fair, and equal.
Senator Lucero.
Thank you, Mr. Chair. Okay, so I didn't get an answer for clarity. I'm just seeking clarity. And so, Mr. Chair and Senator Dibble, in the answer that was just given, in the list of civil authorities, one of them that you just listed, Mr. Chair and Senator Dibble, was the legislature. So, and I agree, the legislature is would be in the realm of a civil authority. But then if a future legislature were to pass voter ID, and then a local election judge or whatever downstream civil authority were to attempt to enforce that, would my understanding be correct with the author's intent that would be prohibited if this were to become amended into the Constitution, that a civil authority would be prohibited from enforcing a future legislature duly passing voter ID?
Senator Dibble.
So, Senator Lucero, you're trying to draw me into a conversation that I said I was not going to participate in, which is specifically around voter ID. I'll draw you back to the language of the proposed constitutional amendment. Elections shall be free, fair, and equal, and no civil or military power shall interfere with the free exercise of the right to vote. So, how I would respond to you is the legislature needs to examine the language of any legislation it proposes against the constitutionality of that language. And the legislature being a civil authority, and of course, you know, those who are then tasked with enforcing or administering policies and laws would have to follow the law.
Senator Lucero.
Thank you, Mr. Chair. I would like to propose an oral amendment.
Senator Lucero, do you have your amendment in writing, or is it verbal?
It's an oral amendment.
an oral amendment.
And it was based on the catalyst of just this conversation and some concerns that I have.
Okay. Please propose your amendment. Senator.
Thank you, Mr. Chair. So I'm concerned that, and I can appreciate not wanting to get into the discussion of a voter ID, the merits, the demerits, I can appreciate that. But I'm concerned that a future court could interpret this word civil as prohibiting a future passage of statute requiring voter ID. So therefore, to ease my concern, my oral amendment is on line 1.8, after the word equal, insert ensuring one eligible citizen, comma, one vote. So the line would read, elections shall be free, fair, and equal, ensuring one eligible citizen, comma, one vote. And I would like to ask a roll call on that oral amendment.
Roll call requested, roll call granted. We're talking with council right now to see if we have, yes, council is going to restate the amendment.
Thank you, Mr. Chair and members. The amendment is on page 1, line 8. After equal, insert comma, ensuring one eligible citizen, comma, one vote.
There are other questions in the lineup here. And I guess I want to ask if the questions that anyone has are related to the amendment. So do we have a question on the amendment? From what I understand, do we have one member that would like to ask a question on the amendment? And first, I'll have Senator Dibble give his reaction to the amendment.
Well, I'm kind of responding on the fly here. I of course opened up my own comments talking about one person, one vote, one citizen, one vote. I don't think this necessarily gets us to requiring one particular outcome that I'm speculating on motive that Senator Lucero would want this to drive at. Probably the word ensuring, might get us to that, implied requirement that there be a voter ID, which we have found, and the citizens of Minnesota have rejected the proposed constitutional amendment to that effect. But I'm just kind of thinking out loud here, tap dancing while I formulate my response. So the short version is, Mr. Chair, I don't think this necessarily does the amendment a lot of damage. So I don't have a strength of feeling. So I would invite other people to respond with how they feel, and or just for members to vote as they see fit.
Thank you, Senator Dibble. Senator Swanson.
I would suggest a no vote on the amendment. I think your bill is pretty clear and pretty concise and to the point, and I love that, the cleanness of the language, even though maybe we don't know what free, fair, and equal are going to be defined as, but I just love that it's like most constitutional amendments, they're quick and to the point and uncluttered by verbiage that maybe is unnecessary. So I'll be voting no on the amendment.
Senator Dibble.
Mr. Chair, at some point I want to get back to what free, fair, and equal mean. I think we take some guidance from how other states have ruled. I'll just put it at that. I'll just leave it at that. I won't come back to it. But Mr. Fisher has some thoughts, if you could.
Mr. Fisher.
Thank you, Mr. Chair. The one thing I know in my practice, and I've been a lawyer for longer than most of you have been around, I think, is that the more language you add to an amendment to a constitution, the more ambiguity it reads into it. I think that I agree with the senator that the language that we have now that is in the current authored bill is language that is used in 30 other states. I can say that 13 use the words free or equal. Some use just free. Some say free and open. Others use free, open, and equal. These are time-tested languages that have passed court muster over the past several decades, if not longer. And now we're adding additional language to try to meet a specific need. Is going to create more ambiguity around that tested language. And so my recommendation would be that it not be added, but that's my own personal view, and on behalf of Clean Elections Minnesota.
Senator Lucero, reaction?
Final remarks?
Yes.
Okay, I'm concerned with what I heard from my colleague, Senator Swanson, that it is clean and succinct, but meaningless. Lacks meaning, lacks clarity. What I'm seeking to do is to bring some clarity. I do not want to have a constitutional amendment where we admittedly have members suggesting that it's not clear. Ensuring that one person and one vote is part of the Constitution is to bring that such clarity, and I encourage a green vote. Thank you.
Thank you, Senator Lucero. We have a question from Senator Westland. Senator Westland.
Mr. Chair, I think Senator Lucero spoke to his amendment. The only thing I will add is there are a whole line of Supreme Court cases that identify the concept of one person, one vote. And I will be voting no on the amendment.
Any other questions from members? And we have a roll call vote, and I'll ask the clerk to take the roll.
Chair Carlson.
No.
Senator Curran.
Yes.
Senator Westland.
No.
Senator Barr.
Aye.
Senator Bolden.
No.
Senator Swazinski.
No.
Senator Limmer.
Yes.
Senator Lucero.
Yes.
Senator Marty.
No.
Senator Matthews.
Yes.
Senator Port.
No.
There being 5 ayes and 6 nays, the motion does not prevail.
Continuing on, Mr. Chair.
Senator Lucero.
Thank you, Mr. Chair. So that's unfortunate. I'll try one more. And again, these are just coming out on the fly as a product of the conversation that's occurring. And so I'd like to propose one more oral amendment, Mr. Chair.
Senator Lucero.
Thank you, Mr. Chair. On that same line, 1.8, after the word shall, insert have integrity and. So the line would read, elections shall have integrity and be free, fair, and equal.
Council will reread the wording that we're considering.
Mr. Chair and members, on page 1, line 8, after the first shall, insert have integrity and a question for you, Senator Lucero. Do you also then want to amend the question on 1.13 to include the same language?
Senator Lucero.
Thank you, Mr. Chair. I was contemplating that, And I have a note written down here at the end of line 1.13, it could read, and equal elections with integrity. Because the question submitted to voters does not need to be identical to the product, obviously, that will be amended. And so I think the cleanest way to have that would be to add that. So I appreciate that suggestion at the end of line 1.13.
Thank you, Senator Lucero. Do we have a reaction from Senator Dibble?
And I'll speak to that, Mr. Chair.
Oh, all right, Senator Lucero.
Thank you, Mr. Chair. And the rationale behind this is, as somebody who's a cybersecurity professional for over 20 years now, one of the precepts that we are enforcing or striving towards, is maybe a better way to put it, is an acronym known as CIA. CIA, as a security professional, stands for confidentiality, integrity, and availability. And many of these conversations that take place in the context of elections are, certainly we agree with the concept of confidentiality. When a person is casting their vote, it is unknown who they're voting for. And then the other end of that acronym, the availability, is to have access, to be able to have the means to cast that vote. So we're well aware of the confidentiality and the availability of that principle. So this deals with the integrity. Because it's a well-known concept, I think that it is something that we value and should also uphold in our elections, in addition to the confidentiality and the availability. And therefore, Mr. Chair, I encourage a green vote, and I ask for a roll call.
Roll call requested, roll call granted. Let me get Senator Dibble first. We have Senator Bolden on the list. Senator Dibble.
Thank you, Mr. Chair. I'm in favor of, I'm pro-integrity. I'm not pro this amendment for the reasons that Mr. Fisher cited earlier, that and what Senator Westland said earlier as well, that we have some language that has been tested, that upholds our shared goal and value, as I best understand what everyone has said. And so I think through our state laws, we can provide for the integrity of voting and election systems that uphold the idea that they be free, fair, and equal, free from interference. So I recommend a no vote, Mr. Chair.
Thank you, Senator Dibble. Other questions? Senator Lucero, any further response from
I'll go last.
Senator Dibble?
I'll go last for closing remarks.
Okay. We have Senator Bolden, who is asking. I'm sorry. Senator Westland is waving. Okay, I'll get to you. I already asked Senator Bolden to give her thoughts.
Thank you, Mr. Chair. I'll be brief. So what we're talking about is consequential. It, has implications for amending the Constitution. I appreciate the testifier's comments about sort of proven language that is in place in other states and has been proven the test of time, through the courts and such. And so I think we should be really intentional about the language that we are talking about, and sort of making changes on the fly and in the moment concerns me a bit. I think as this bill moves forward, there's time to have those conversations and to be thoughtful and take some time to think really if there should be changes, really what that language should be. And so I'm a no on this amendment for those reasons.
Thank you, Senator Bolden. Senator Westland.
Thank you, Mr. Chair. I'm very sorry I'm not able to be with you there today. This is so awkward to be on Zoom and trying to do this. I guess, would Senator Lucero, may I ask you a question? Mr. Chair, can I ask Senator Lucero a question?
Senator Lucero will.
I love answering questions, Mr.
Okay.
Chair. Sometimes they take a while to answer though.
Oh, dear. So that might make me rethink this. Just kidding. Senator Lucero, is there any other state that has that language in a similar constitutional provision?
Senator Lucero.
Thank you, Mr. Chair. I do not know the answer to that because I am going through this in committee here, and I'm coming up with responses to satisfy my concerns, and I know the concerns of many Minnesotans in this committee process, and as I'm asking questions to the bill author. So I've not had the chance to look at 49 other constitutions in the last 10 minutes or so.
Mr. Chair, I guess I would sort of echo Senator Bolden and just say, generally speaking, when we're considering language that's going to go into the Constitution in particular, I think we need to use great care and not be doing things on the fly. But I will tell you that I have pulled up from NCSL a list of states having the free and equal elections clause, and there are a number of them, including red states and blue states, that have similar language to what Senator Dibble is proposing, none of which include the language being proposed by Senator Lucero. Idaho says no power, civil or military, shall at any time interfere with or prevent the free and lawful exercise of the right of suffrage. Indiana, all elections shall be free and equal. Missouri, that all elections shall be free and open, and no power, civil or military, shall at any time interfere to prevent the free exercise of the right of suffrage. Montana, all elections shall be free and open, and no power, civil or military, shall at any time interfere to prevent the free exercise of the right of suffrage. I am going to oppose this and potentially any other amendments that Senator Lucero might think of on the fly, with all due respect. Because I think that the language Senator Dibble is proposing today is actually consistent with what many other states have done, including both red states and blue states. And I think that we should vote this amendment down.
Any other questions here? Senator Barr.
Thank you, Mr. Chair. Just a general comment on the amendments here. It's 39 other states have done something similar. We don't have to be a cookie cutter. We don't have to copy and paste. We do have the ability as a sovereign state to write our own amendment with the language we think is best. So being restricted to what 39 other states have done, I think, is a misnomer. Thank you, Mr. Chair.
Thank you, Senator Barr. Any response? Senator Lucero.
Just wanted to be last, assuming you have nobody else in there.
Lance, I thought you were asking for time. Okay, any other questions? Any other comments? I'm sorry. Okay. So Senator Lucero, looks like we don't have any other questions, so now you're last.
Okay, thank you, Mr. Chair. So what I would add to what Senator Westland said is, in the examples she cited, goes into decades past. We've seen recently the continued evolution of the use of technology, misinformation, disinformation, election interference. We recently saw the headlines of artificial intelligence by China and how they potentially might be advancing over some of our own technological advances in the United States. One of the things that I'm concerned is the continued evolution of this technology and how it can be used for nefarious purposes, including in elections. So one of the things that I'm concerned about here is that in decades past, in the constitutions that Senator Westland cited, they didn't have the similar threats that we face today. And by inserting the word integrity there, I am attempting to ensure that the data is not corrupted, that the process has the necessary controls in place to ensure that the data, the votes, are not compromised, not interfered with. And so because we in the state of Minnesota have not had this for the entire time since 1858, and we're now just discussing to add it to our Constitution, we should also take seriously and look forward to the threats and not just be looking 100 years back. And so that's the reason why I think it is absolutely our responsibility and should include the word integrity to protect our elections. And with that, I encourage a green vote. Thank you, Mr. Chair.
Thank you, Senator Lucero. We have a roll call requested. The clerk will take the roll.
Senator Carlson.
No.
Senator Curran.
Yes.
Senator Westland.
No.
Senator Barr.
Aye.
Senator Bolden.
No.
Senator Swazinski.
Nope.
Senator Limmer.
Yes.
Senator Lucero.
Yes.
Senator Marty.
No.
Senator Matthews.
Yes.
Senator Port.
No.
On the motion for a roll call, for a oral amendment, there being 5 ayes and 6 nay votes, the motion does not prevail.
So, Mr. Chair, I'll wrap it up.
I'm sorry.
I'll wrap it up.
Okay. Senator Lucero.
Thank you, Mr. Chair. So with that, unfortunately, the lack of adopting, I think, 2 common sense proposals, the voting down that one person would equal, or one eligible citizen would equal 1 vote, and the opposition to ensuring integrity in our election system, I therefore cannot vote for this piece of legislation before us, Senate File 529. Thank you, Mr. Chair.
Thank you, Senator Lucero. And do we have Senator Limmer would like to speak?
Thank you, Mr. Chair. I was looking over this. I've been listening carefully to the discussion. The words free, fair, and equal, as we all know, are very attractive terms. I don't think anyone would disagree with those terms that would highlight this proposed amendment. I've been thinking about some of the recent discussions we've had last year in this committee, and for example, the term equal, I would assume that pop-up polling places that would create a second polling place in a precinct would now be considered a violation of equal, because it would try to maximize a vote in one precinct above any and all others. I hope we're giving kind of some thought to what would be the after effect based on what we have in our existing laws. The other thing I had a question of is, what happens if we had a national or a state emergency that would cause a danger to the public to vote? There's been a lot of suspicion that certain candidates, once they get into office, would announce a national emergency, and therefore it would take the election franchise away from the public. But let's say there was a real national emergency, an attack. Weather is always a common issue in especially northern Minnesota. That action announced by a civil authority, does that interpret into interfering with the right to vote? That should maybe be discussed. The right to judicial review that Senator Dibble spoke of, I'm not quite sure how that works without a court case bringing it to the attention of the judiciary, and we don't usually go to the judiciary and ask for a review before matter of fact, I don't think they would even make a comment about it because it would violate their impartiality. So I'm not sure how that really fits into our discussion. Those are some of the questions that I had. I certainly agree in the concept of free, fair, and equal elections. We all should. But deciding this in 1 hour and 9 minutes, I think is kind of rushing it a little bit. the bill was introduced 14 days ago. This is the first that I've caught up with it. I would like to have a little more discussion about it myself. And certainly there's been reference to case law on both sides of this debate, and I haven't heard any cites on that. I would like to review that before I would cast a vote. I just think that, you know, there's other things, let's say anticipation of future legislation. If this particular proposal went into effect and became law, anything that one would do in order to create a requirement like photo identification for a voter could be construed as unconstitutional based on it interfering with the right to vote. We certainly heard in 2012 the debate points that were brought up by people opposed to a constitutional referendum in 2012 that said the very words, it's unfair, it's not equal. This is going to deny the right of vote for certain people groups. And this would be a perfect argument to sustain a repeal of that particular law. The judgment would be clear and it would be considered unconstitutional now that it's written into our Constitution. And let me underline, I believe in free, fair, and equal elections. I'm trying to create a bulletproof concept that ensures that with our public, but at the same time allowing a state to have the freedom to write laws that would enhance a true representation being the result of an election. Some people think a photo ID would accomplish that. Other states have also put that into effect. And maybe the federal government is kicking that idea around too. So could we, in a short period of time, be creating a potential conflict in law right now if we pass this? Or if the public granted this. It sounds great, sounds really patriotic, but at the same time, I just think we need a little bit more study on this. I would hope we don't pass this, but that we lay it over, Mr. Chair, for further review.
Senator Matthews is on the list. Senator Matthews.
Thank you, Mr. Chair. I have an amendment that is in writing for us to look at. I would like to offer the A2 amendment.
Senator Matthews offers the A2 amendment. It's being passed out.
And I can speak to it now that it appears to be passed out.
Just want to make sure that our online members have received the amendment.
No, they haven't, not yet.
Just give them a moment. we are still working on getting that amendment out. Perhaps while we're still working on that, Senator Matthews, maybe you can explain your amendment.
Thank you. Thank you,
Mr. Chair, I was going to say, just to be expeditious at time, could we just read the amendment out for the members who are not here?
Mr. Chair, Senator Cran, my A2 amendment's very short, very simple. After the words that elections shall be free, fair, and equal, this is inserting the words transparent and secure. Would give two extra values that are high values that we would respect on a bipartisan basis with here. This would make sure that in our Constitution, elections, we have this protection embodied in our Constitution to make sure that there is the transparency and security that Minnesotans believe in and require of us, and gives a constitutional level recall or mechanism for any failures to do so. If there are egregious errors made that clearly show that elections have not been transparent, if ballot custody has not been kept up to the standards required in law to show that they've not been fully secure, this gives a recourse for being able to ensure that along with free, fair, and equal elections, we have transparency and security within our Constitution. So it also go a good ways towards combating misinformation that both sides talk about wanting to make sure doesn't interfere with elections, so that we can tell our voters that we have the right of transparency in our elections embodied in the Constitution, and a judicial review process for making sure that standard is enforced. So I would ask members to consider adding this to this proposed constitutional amendment, and depending on the, I'll let the author give his response before making a decision on a roll call, Mr. Chair. Thank you.
Senator Dibble.
Thank you, Mr. Chair. I am pro-transparency and security. I would just, again, similar to Senator Lucero's amendments, just draw your attention to the prohibition on the interference with the free exercise or the right to vote. I think, some of these concepts are covered by that language, both in the Lucero proposal as well as in the Matthews proposal. Again, I go back to the points that Mr. Fisher made, that Senator Westland made. We have language that we know how it's viewed by the courts, how our laws are judged against the fundamental rights that we're trying to confer through this constitutional change. I'm wide open and available to this discussion, whether this language belongs as a constitutional principle or whether it belongs in our state laws that seek to uphold the constitutional principles that we're setting forth. I think is a good discussion, and I'd love to engage in that discussion with Senators Lucero and Matthews. But at this time, I don't think we should be inserting these particular adjectives into this language.
Thank you, Senator Dibble. If I'm hearing you correctly, you would be interested in speaking with the amendment authors if that was something that they were dedicated to. And I guess what I need to say too is that if these were brought up ahead of time, we might have been able to get some understanding between exactly what the amendments mean and if they are actually adding to the complication of this constitutional amendment or taking away. And so with that, I guess I'd like Senator Matthews' response.
Thank you, Mr. Chair. Appreciate your comments, but respectfully disagree. I think we can read this here and be able to determine what these values mean, and they're important to us. The whole fundamental reason that we have this bill is arguably that these things aren't in law, so we need to put them in the Constitution. Now we're arguing, well, we do have some of these things in law, so we don't need them in the Constitution. And I do agree, we do have some requirements for transparency in law. As we've recently discovered, the law was not sufficient enough to have anything done about it after judicial review. There was nothing done after effect when some transparency and security were clearly violated. So I think this does have the importance of needing an even higher protection to ensure that elections remain transparent and secure. So I would ask for a roll call vote and a yes vote on my amendment. Thank you, Mr. Chair.
Mr. Chair.
Senator Dibble.
With apology, I didn't realize we were on the last word. If I could step on Senator Matthews' last word, because Mr. Fisher had a thought he wanted to share, if that's all right.
Thank you. Mr. Fisher.
Thank you, Mr. Chair, and I don't want to step on anybody's thought, so I'm just going to come up as a citizen and react a little bit to this. Because of recent history over the past 10 years or so, which is recent, I just have to look at this and say that this language, transparent and secure, can easily lead to challenges onto whether elections actually are transparent and secure based on any number of different conspiracy theories. And I think it's just another avenue for litigation, and one of the things we're trying to do with this amendment, I believe, is try to prevent that from happening, and that is litigation over elections.
Thank you, Mr. Swanson. With that, we've had a roll call requested, and the clerk will take the roll.
Senator Carlson.
No.
Senator Coran.
Yes.
Senator Westland.
No.
Senator Barr.
Aye.
Senator Bolden.
No.
Senator Swazinski.
No.
Senator Limmer.
Yes.
Senator Lucero.
Yes.
Senator Marty.
No.
Senator Matthews.
Yes.
Senator Port.
No.
Matthews A2 amendment. The vote is 5 aye and 6 nay, so the amendment does not prevail. Senator Westland, you're on the list here.
Thank you, Mr. Chair. I understand we're now on the main bill before us. So I heard a lot of conversations today, and there seems to be some misunderstanding between the purpose of constitutions and the purpose of codes and statutes. And the Constitution is not a code. Constitution is for the purpose of outlining the broad principles, freedom of speech, freedom of religion, etc. And codes fill in the gaps, and codes provide the detail about how we conduct business on things such as elections. There are, as has been mentioned, any number of other states that have adopted similar language into their constitutions. And as we know, states conduct the elections. The federal government, federal Supreme Court have determined that there is, in fact, a constitutional right to vote, but it is up to each state to determine how those elections are conducted. And this is a principled statement that, as with our many other states around the country, a principle that we want our elections to be free, we want our elections to be fair, we want there to be equality, we want them to be equal and open. And so I will be supporting this bill, and I want to thank Senator Dibble for bringing this forward. Thank you for the discussion today.
Senator Dibble, final remarks.
Just thank you for the time and the really excellent debate and conversation. I do take Senator Lucero, Senator Matthews, Senator Cran, and others' comments to heart and want to continue those conversations. But I'll just end by saying I think this is a glaring omission in the Minnesota State Constitution. And I think if we were to put this on the ballot, it would pass by a factor of 80, 90%, because I think it is so abundantly clear that our elections should be free, fair, and equal, and we should not have interference in them. I think people would be surprised that this language is not in our state's constitution, and it would go far to making sure that we have confidence in the integrity, the transparency, the security, and our fundamental right to exercise our fundamental franchise in this representative democracy. Thank you, Mr. Chair.
Thank you, Senator Dibble. And thank you for bringing 529 to the committee. This was a robust discussion, and I think there's going to be more yet to go. But I think it's a good bill, and I will be supporting it. And so with that, Senator...
Mr. Chair, I would like to move to lay the bill on the table.
Senator Limmer moves to lay the bill on the table.
And as discussion, Mr. Chair, I certainly raised some serious questions. I thought I did not get any response from them. Senator Dibble has admitted that he wants to keep working and talking about this bill, and that work should be done in the election committee, not somewhere else behind a door or in a hallway or on the floor of the Senate. We should bring a finished product to the Senate for not only the benefit of discussion, but for the benefit of the people of Minnesota. So I believe the bill just isn't perfected yet. And so I renew my motion to lay the bill on the table, ask for a roll call vote.
Mr. Chair.
Senator Dibble.
Just to clarify the record, I did not indicate that I wanted to keep talking about this bill. I want to keep talking about the issues that were raised in the debate.
Thank you, Senator Dibble. And I guess I have a question for you, Senator Dibble. What was the prior bill that had the same language in it that you mentioned in the beginning of the committee meeting?
That was 2023, introduced in 2023, Senate File 48, identical to this bill.
And I'm sorry, what was the bill number?
48.
So it was early in the session.
Yes.
So it's had plenty of time to be reviewed and discussed. And you've had plenty of time to evaluate any possible amendments. So with that, we have a motion on the table for to lay it over, and with a roll call, the clerk will take the roll.
Senator Carlson.
No.
Senator Curran.
Yes.
Senator Westland.
No.
Senator Barr.
Aye.
Senator Bolden.
No.
Senator Swazinski.
No.
Senator Limmer.
Yes.
Senator Lucero.
Yes.
Senator Marty.
No.
Senator Matthews.
Yes.
Senator Port.
No.
On the Limmer motion requesting laying over, we have 5 ayes and 6 nays. The motion did not prevail. With that, we're going to go to motion by Senator Bolden to move Senate File S529, SF 529 be recommended to pass and referred to the Committee on Rules and Administration. The clerk will take the roll.
Senator Carlson.
No. I'm sorry, that was a yes.
Senator Carlson, aye. Senator Coran,
No.
Senator Westland,
Yes.
Senator Barr,
No.
Senator Bolden,
Aye.
Senator Swazinski. Yes. Senator Limmer,
No.
Senator Lucero,
No, and by no, I mean no.
Senator Marty,
Yes, and by yes, I mean yes.
Senator Matthews. No. Senator Port.
Yes.
On Senator Dibble's Senate File 529, motion to pass and forward to the Committee on Rules and Administration. The vote is 6 aye and 5 nay. The motion prevailed, and the bill is forwarded to the Committee on Rules and Administration.
Thank you, Mr. Chair and members.
Now, we have another bill that, and I see we're at 4:30. I'm not sure if we're going to be able to have time here, so if we can be prompt in this, maybe we can finish today. Otherwise, we might be forced to be long or to come back. Senator Marty has Senate File 529. Senator Marty.
Thank you, Mr. Chair. Senate File 569.
569,
Is a
sorry.
bill we had last year and 2 years ago in this committee, has passed there as well. This deals with, it's a proposed constitutional amendment. It's memorializing Congress to pass a constitutional amendment to address some of the things raised by Citizens United, namely that artificial entities, corporations, other entities of one or more people do not have constitutional rights as persons, that persons, constitutional rights are for natural persons as the law would treat them, in other words, human beings. And number two, that money is not free speech, and that we want to have states and federal government regulate election spending in a way that ensures that no person has substantially more clout than other people because of their money. And this is I would flatly state something I think most people believe, and I think it's true, and that is that political money is corrupting our democracy. There's $16 billion spent last year in the election. The public poll, Pew Research poll about a year and a half ago said they were asking how people feel about who has influence on members of Congress. 80% of the public believe people who donate lots of money to campaigns have too much influence, 80 versus 7% who think they have too little. 73% believe lobbyists and special interest groups have too much clout, 10% think too little. In contrast, 70% think constituents of members of Congress have too little influence. It's overwhelming public belief that money is corrupting our political system. Sometimes when we think of that, we think of the worst types of corruptions, bribes, quid pro quo deals, and so on. Sometimes people get caught in prison for that. U.S. Senator Robert Menendez is now in prison for bribery. It's difficult to prove. This is a long history. This is not something new in our democracy. Over 100 years ago, early in the 20th century, there was a Pennsylvania U.S. Senator named Boyce Penrose who was very close to, at that time, and this was the Gilded Age, the railroad tycoons and oil barons, and he told them, quote, "I believe in the division of labor. You send us to Congress, we pass laws under which you make money. And out of your profits, you further contribute to our campaign funds to send us back again to pass more laws, enable you make more money." And last year, there was reports in April of then candidate Trump meeting with some oil and gas executives at Mar-a-Lago, in which they were complaining about, despite having poured hundreds of millions of bucks into lobbying at the federal government, the Biden administration had pursued stronger environmental regulation. Washington Post reported Trump's response stunned several of the executives in the room overlooking the ocean. "You are all wealthy enough," he said, "that you should raise $1 billion to return me to the White House. In exchange, he vowed to roll back current regulations and freeze future ones." He told them giving the savings $1 billion would be a real deal for them. Without saying that this thing is the everyday kind of behavior, I think most of the problem isn't direct quid pro quos or bribery. I think buying access is the term I think many people would use. I think both donors and politicians claim there's no link between campaign contributions and political favors or votes, but we treat campaign contributions to gain access to politicians as perfectly legal and perfectly appropriate. But that's not the way it works, and the money in the process is not equal. There's no way it's equal. One individual last year, Elon Musk, put in $277 million in the presidential campaign. I think a lot of us have a lot of donors to our campaigns, people who give us $100. To me, I've had personal limit of that for many years. And these are people who, many of them can't give $100. Fortunately, the state has this nice law for the refund thing, which helps a lot of people. But those $100 donors, again, which many of our constituents couldn't afford to give that much, is less than 1/2 millionth of the clout that one individual has, and that individual who now has a huge role in the new administration and the reshaping of the federal government. Some might argue, and I would argue as well, that it's partly because of the money that get them there. I believe that big money is a dominant force in determining what issues are raised and discussed, who wins elections, even who runs for office. People, many times, candidates say, well, I couldn't raise the money, I'm not going to even try. Big money doesn't just simply affect who gets into office, it also affects what happens there. Big money influences at times who chairs committees, who has the ear of powerful lawmakers, who gets the chance to talk to them most. And about 15 years ago, one congressional staffer watching the influence of powerful lobbies in Washington suggested that if this were NASCAR, members of Congress would have to have corporate logos sewn on their sponsors, sewn on their jackets. And other than Senator Lucero, most of us don't have that colorful of jackets, but I think the patches would be a disclosure thing. But I don't want to make this about bribery and that sort of thing. I want to say that it's an insidious process in which powerful interests with a lot of money, they buy elections and gain influence and goodwill through their campaign contributions. I think the vast majority of public officials are honorable people who would never sell their vote, but the corrupt process has a very real, albeit subconscious, impact even on well-meaning people. So I'm going to quickly just go through the bill. It's, as I said, it's a resolution to Congress. The first clauses of it, the whereas clauses, are basically talking about some of the history of this. In 1976, first of all, constitutional rights, corporations were created by law. There were no such things as corporations till 150, 200 years ago, when states and the federal government started creating corporations, which is perfectly appropriate. It's a good way to organize things in society. But giving those artificial entities constitutional rights of their own is problematic. And also, in 1976, Supreme Court in the Buckley-Vallejo decision talked about, they put caps on campaign limits because they said the First Amendment, which they were trying to protect, is designed to, quote, secure the widest possible dissemination of information from diverse and antagonistic sources, to assure the unfettered interchange of ideas for bringing about political and social changes desired by the people. That's the point of the First Amendment, so we can have the vibrant debate. But the money, when some people, even if it's two sides of an issue, they dump in tons of money on it, other perspectives are never heard. It determines, as I say, who runs for office, who has a chance of getting nominated, who wins, all steps of the way. And I think many of us have heard, if you talk to congressional candidates, how many hours a day they spend on the phone dialing for dollars. I think it's a corruption of our process. So this would have the legislature request Congress propose an amendment to the Constitution that would substantially say the rights of the Constitution are the rights of natural persons only, and that other entities, organizations, associations, or one or more persons have the rights and responsibilities we give them through law, but they don't have constitutional rights beyond the rights of its members. We all have rights to free association, we have rights to free speech, and we can work with others, and so in those entities, they have that power, but they shouldn't have constitutional rights to give money and everything else to campaigns. And the second major cause of this is that federal, state, and local governments shall regulate, not may, but shall regulate, limit, or prohibit contributions and expenditures, including a candidate's own contributions and expenditures, to ensure all citizens, regardless of economic status, have access to the political process, and no person gains as a result of their money substantially more access to the process. That's the gist of it. I'd love to have your support, and I have several people to testify on the bill, and I think you have the order you would like them to be presented.
Thank you, Senator Marty. We do have your testifiers listed here. And if you don't have a different preference, we'll just go by the list that you have here, which I have the first two are Jeff Clark and Andrew Ibben, and they're both from Move to Amend. And I guess the two gentlemen will have you decide who is going to speak first and how you're going to complement each other.
Okay. Thank you, Senator Carlson, Chair, and committee members. Good afternoon. I'm Jeff Clark, and I'm a volunteer supporter with Minnesota Move to Amend. SF 569 calls for, I'll be elaborating some of what Senator Marty has presented, but a constitutional amendment that expresses two principles, basically, that could use some clarification, though. A little expansion, judging by questions that have been raised in past versions of this bill. First is that only human beings or natural persons have U.S. constitutional rights. Every organization or other entity created by legal instruments is not entitled to these rights. They should have instead privileges written into law. This permits the governing laws to be flexibly updated rather than set in stone by courts interpreting the Constitution to include them as persons as well with rights. Regarding entities created by legal instrument, the amendment's scope would include every type of corporation, including benefit corporations, nonprofits, unions, and even farmers' cooperatives should they become politically active, any organization. Second principle is that money raised and spent in the political campaign process is not equivalent to free speech and should be regulated, must be regulated by Congress and made publicly transparent. Congress would be authorized to establish campaign finance law for the different categories of campaign contributors so as to level the playing field for participants and not disadvantage the average citizen in the political process. A constitutional amendment based on these two principles would authorize and require Congress to write implementing legislation. Obviously, that's going to take time, but the legislation could then be improved over time, adjusting to practical realities and improving its effectiveness across successive Congresses. The other consequence, though, of the amendment would be almost instantaneous. It would require the U.S. Supreme Court to cease using the opposite of these two principles, that corporations, et cetera, are persons with rights, and that spending money in politics is the same as speech and can't be constrained when they form their opinions on litigation that tends more often than not to favor powerful corporate and money interests. Removing these two options in court reasoning could have a significant impact in favor of social, environmental, and other kinds of welfare for the common citizens. So in summary, what the resolution does propose is the most complete solution to addressing what is the full problem: how to make our government more responsive to all the citizens who elected and serve to serve and protect their interests. Therefore, I urge you to vote for SF 569 as the first step toward making Minnesota the 23rd state to petition Congress to draft an amendment like the one I've just described here. Thank you.
Thank you. So, Mr. Chair and committee members, my name is Andrew Irvin, and I'm also a volunteer supporter of Minnesota Move to Amend. And my testimony focuses on concrete examples that illustrate the two principles of this bill's called for a constitutional amendment that were described by my colleague Jeff Clark just now. Treating the spending of money in the political process as free speech is the principle most visible to the public when they speak of reversing Citizens United. Citizens United versus FEC and the SpeechNow.org versus FEC decisions, both from 2010, have had a massive negative impact on the American political system. SpeechNow.org was heard in the U.S. Court of Appeals for the D.C. District. This decision determined that its analysis of Citizens United required it to conclude that the government has no anti-corruption interest in limiting contributions to an independent expenditure group. The U.S. government declined to appeal this decision in the face of Citizens United. As a result, super PACs now have essentially unlimited fundraising and spending capabilities. The other principle in Senate File 569 involves denying corporations and other entities created by legal instruments the status of persons with constitutional rights. Because the Supreme Court has maintained for decades that they are persons, corporations have been able to apply useful amendments to deflect accountability to laws through litigation. Here in the state of Minnesota, Sands versus County of Winona, the company took the county to court over its ordinance prohibiting industrial mineral operations. The company wanted to mine silica sand to export use in fracking operations out of state. The linchpin premise of the suit was that the county was violating their Fifth Amendment right to future profits under the takings or just compensation clause. Why? Because of the Supreme Court's lead in treating corporations as persons entitled to such rights. In this case, Winona County eventually won the suit. However, more often, state and local laws protecting their citizens are thwarted in courts, or knowing that this is likely the outcome of expensive litigation, the government entity may not even create such law in the first place. We have a crisis in big money in our elections and corporate power obstructing our government. A constitutional amendment described in this resolution would eventually cure the problems described above. Please support Senate File 569 as an important step toward returning power to citizens whom our government is meant to serve. Thank you.
Thank you, Mr. Irvin. Senator Marty, you have other
Yeah, I believe,
persons.
I don't know if they were planning, but I think Emma Rage and David Fisher were going to speak briefly as well.
Please be as succinct as you can, please. We're getting close to the end of our time here. So, Ms. Rage, please give your name and who you're affiliated with and proceed with your testimony.
All right. Good afternoon, Mr. Chair, members of the committee. My name is Emma Rage. I am the Policy and Civic Engagement Manager with Common Cause Minnesota. I'm here in support of Senate File 569. We support the resolution asking that Congress overturn the United States Supreme Court decision in Citizens United v. FEC and propose a constitutional amendment to get it done. Preliminary reports from Open Secrets estimates that the amount of dark money spent in 2024 on federal elections alone came in at a record of $4.5 billion, and more than half of this money came without any disclosure requirements for these donations to nonprofit PACs. Citizens United and the floodgates of unchecked money that it opened has transformed political campaigns into fundraising contests. Candidates spend more time and effort cozying up to big dollar donors than they do addressing the challenges facing our nation and the communities of the districts they are wanting to represent. In Washington, we've seen how this has led to the least productive Congress in memory and a poisonous, hyper-partisan political atmosphere that makes it nearly impossible to imagine progress towards improving the lives of everyday Americans. The cash infusion has been just as damaging here in Minnesota as we struggle with increasing partisan dynamics at our Capitol. And in 2024, we saw an increase of outside money flooding at some of our local elections in attempts to influence our election outcomes. We can do better, and millions of Americans with differing political affiliations nationwide are trying to do exactly that. In the last 15 years, 22 states, DC, and nearly 900 municipalities and counties have passed resolutions like Senate File 569, asking for common sense regulation of big money in politics. This is not a partisan issue. The influx of outside money we've seen in Minnesota is often used for disinformation tactics that hurt both sides of the aisle. And we urge members of the committee to pass Senate File 569 so Minnesota can join the 22 other states asking Congress to pass an amendment to overturn a decision and create a Minnesota with campaigns and candidates that work for all of us. Thanks so much.
Thank you, Ms. Rage. Mr. Fisher is here to testify as well. And this is a repeat testimony today, so please identify yourself again for the record.
Yes, sir. Thank you, Mr. Chair. Members of the committee, Senator Marty. Again, I'm still David Fisher. I'm with Clean Elections Minnesota in support of File 569. On one day in January 2010, the U.S. Supreme Court unleashed a flood of money into our political system by overturning well-established precedents and finding that corporations, and as a consequence, political action committees, have a constitutional right to spend unlimited money to promote or defeat candidates for office. I have similar statistics to what Senator Marty and Common Cause have already presented that tell us that money is proliferate throughout throughout our elections and growing in numbers, certainly on the federal side, but as well on the state side. The National Institute on Money in Politics reports at the state level, Americans have a marked increase in independent dark money spending after Citizens United. For instance, in Colorado's 2006 election, independent spending totaled less than $400,000. The 2014 election saw $33.8 million spent independently, and in 2018, that amount was $136.9 million in independent spending in that one state. And in quoting the National Institute, it boggles the mind. This is happening in states across the United States and in Minnesota as well. I'm sure every one of you knows how the escalating costs of elections is becoming intimidating to those who might want to run for election. Overnight, Citizens United overturned bedrock principles like one person, one vote, and government of, by, and for the people. Now our democracy is at grave risk of becoming nothing more than an auction, one in which we the people will always be outbid. And now, speaking as a law professor and career corporate general counsel, I can say that corporations are not people. They don't breathe or eat or sleep. They don't dance or fall in love or raise children. They don't go bowling or fight in wars or get cancer, and they don't vote. They're fictions created by laws passed by legislatures, subject to laws and regulations approved by legislatures. Yet now they threaten to trample democracy by claiming constitutional protection intended only for natural-born people and defying the authority of our legislatures. Clean Elections Minnesota urges you to support Senate File 569 and its 4 principal points. Corporations are not people. Corporations have no greater rights than the people they employ. Campaign finance can be regulated, and donors to PACs must be disclosed. This is the only way to shine the disinfecting light of transparency on our treasured electoral process. Thank you.
Thank you for your testimony. We have some supportive letters that are in your packets, members, and so from the League of Women Voters and also from a couple of individuals. Now, if we have, Senator Marty, do you have any concluding comments?
Welcome discussion.
Pardon me?
I welcome discussion, Mr. Chair.
Okay, yes, and we have some folks from the committee that have some questions. Senator Barr.
Mr. Chair, with 5 minutes left, is this an appropriate time? Because many of us have questions, and we should flush this out well. can we lay this over and come back now that the public testimony is done, and so the members can have a full vetting, or do you want me just to start, run it to 5 o'clock, or are we staying late? Could you kind of give me some parameters here, please?
We could lay it over for another hearing.
Thank you, Mr. Chair. With that,
I
with
would-
5 minutes left before the committee deadline, I
would
think
leave
this
that-
is an appropriate
Sorry,
time to lay this on the
Senator
table.
Barr, I'd leave that decision up to Senator Senator
Mr. Chair,
Marty,
I'm
if
happy
you
to
would-
lay it over for another date if you would.
Okay. We will lay it over, Senator Barr.
Thank you, Mr. Chair.
Thank you. With that, we are going to lay it over.
Well,
and
Mr.
if-
Chair, isn't that a motion to lay it on the table?
We don't need a motion to lay it over. No.
Well, Mr. Chair, we're not laying it over. We're laying it on the table so we can come back and debate it later.
Okay. Laying it on the table. Do we need a motion?
So, Mr. Chair, I make that motion to lay it on the table.
Okay, Senator Barr makes a motion to lay it on the table, but I'm going to say that if we have many questions, can you please be sure that you contact the author and put, as much as you can, put your thoughts on paper so he can consider them, and we can be a lot faster next time than what we are today, if that's okay with you. So Senator Barr moves to lay the Senate File 569 on the table. All those in favor say aye. Aye. All those opposed, nay? We have a nay? No?
Mr. Chair,
The bill is laid over.
Mr. Chair, I understand that there may not be any further business before this committee, but I did want to raise a point of order.
Senator Limmer raises a point of order. What's your point of order, Senator Limmer?
There happens to be on your agenda page a roster of the members, and there seems to be one missing, so I need to ask the question, is Senator Barr a legitimate recognized member of the Committee on Elections?
No, I will have to get some advice on that. That sounds like that was an error.
Mr. Chair, Mr. Chair, Senator Limmer, after our first roll call vote, I was looking at 11 and counting 10 members, and so I already brought it up to Ms. Blood. So hopefully we'll get that corrected.
Okay, we will correct that, Senator Barr, and you don't have to pack your suitcase yet.
He's kind of a
Mr.
sneaky
Chair.
guy, Mr. Chair.
Senator Westland.
I don't know. Is this kind of like Survivor? Do we get to vote someone on or off the island? I'm just,
Yeah, don't do that, Mr. Chair. I already know who's going to lose that one.
Senator Westland, not when they're all willing.
Okay, so shall we take that as a motion, Senator Lucero? So with that, we don't, Senator Limmer, we do not have any additional business on the agenda, so the Senate Committee on Elections is adjourned.